Hi, it's Anne-Marie from Charmed Life Therapy. I had a day off yesterday, but you don't really get a day off in this case. She says that she sat for hours last night following Popcorn Planet as it covered Perez's court appearance in Vegas, and that was a whole whirlwind for nothing and something and nothing at all, wasn't it? Because between the fact of just waiting around for ages and hanging around the courtroom and listening to people's interpretations of it when they came out. And then within what, an hour, 2 hours, Lyman had already ruled that he didn't have jurisdiction over Perez. Anyway, um, so it kind of just highlights how crazy this whole case is and how frustrating I think as well the law is, because time after time we've had this now where there's all these arguments about who's producing what and whose jurisdiction is what and who should be doing this and who should be doing that. And meanwhile, the law itself in the background is doing its own thing, often fully knowing what it's going to do, regardless of what anybody else is trying to pull together in terms of information or an argument or anything else. That quite often these things mean almost feel like they mean little at all. It kind of seems to be clear from the Vegas end of things that there's been conversations between Lyman and is it Bulwer, the judge over there in Vegas. I think they've come to an agreement between them over what they were going to do. So Perez now has a hearing on Tuesday in Las Vegas, and he gets to actually just fight the issue, which is having his subpoena quashed over providing his information, his sources, his communications with Wayfarer and their agents, I guess, etc., etc. Um, so, so yeah, a lot of time was spent yesterday over nothing, and I think this is when this case drains you as well, because you just think, why am I wasting hours of my life doing these things? So there's also, and I also wanted to take a day, not only because I was tired, but just like in life, I find this court case sometimes when things happen, you're as well to just wait it out for a few days and see what happens, because often things resolve themselves, which is a good life tip as well, because that often happens in life, you find as well. So let's just see. There's some, like, I don't want to go through all of the documents. I don't really see too much point in doing that, but we need a little roundup just to bring things into play. And I know people are mooting a lot as well, this idea that Ryan Reynolds didn't post for his wife's birthday, and what does that mean? And you kind of have to factor in their perspective that that might be their plan, that he doesn't post for the birthday, and then it leads to a whole chain of conversations that take the narrative off elsewhere. There could have been an aspect of that because they're all about deflection and SEO and diverting your attention from where attention needs to be. So there could be an element to that of it. I don't particularly think he can extract himself, if he wants to extract himself from his marriage until all of this is over, because it's not a good look. Because when push comes to shove, they have 4 children together, don't they? So even if he's angry about what they've gotten themselves into through actions he's blaming her for, I still think he wouldn't jump ship before it's all over and tied up in a bow and the rest of it. So it kind of does kind of bring back into question this idea of how much did he know? Did he start doing all of these things that he did do to Justin Baldoni because he was angry about what happened to his wife in terms of alleged SH? But it's like no man's reaction ever, isn't it? If that was the actual path he chose. My feeling kind of, and I know I've commented with some of you in the comments, that I think there's truth to all of the narratives, all of the stories, that it's literally a bit of everything that is involved here. And it also boils down to their personalities and how reactive and triggered they get over certain things too. Because while most husbands would not respond to the wife being SH'd in the manner that Ryan has, he would see stripping Justin of every bit of control of his movie and making jokes about the furore surrounding it and making Baldoni lose his agent. Ryan Reynolds may well feel that is an appropriate response to your wife being SH'd. What do we know? But I still would struggle to believe that Ryan thought his wife was SH'd on this set, but he was angry that his wife's head was turned by another man, I suspect, and that there might have even been a slight chance that that was reciprocated in his own mind, in Reynolds' own mind. And I do believe there was probably an argument in the trailer, and you know, there was that narrative going, wasn't there, that they were heard arguing in a trailer on set and such as that. I think it was a whole combination of things. The pair of them, I think, must be just completely oversensitive. So, what is going on in the case? We just filed just before I was about to come on. Lively's team now have asked for permission to submit a 5-page letter in response to Jed's objection to them trying to compel discovery from him. So it's interesting, the Perez argument over jurisdiction, isn't it? Because I totally would understand Jed Wallace stalling on producing things, not wanting to, because he must be thinking, this guy has no jurisdiction over me. Where is my motion? You know, where is that getting answered, that these guys don't even have jurisdiction over me? So what, I know, like, you have to be seen to be doing all the things in the meantime, but from Jed's perspective, I guess he's pretty peed off because he's already got himself out of this once. She didn't present anything more compelling to keep him there in a second amended complaint. He just wants out of it at this point so he can continue his prosecution of her in Texas. It's nearly all about jurisdiction and free speech at this point, and nothing to do with SH, which is, you know, kind of ridiculous, isn't it? So they've come up with this 5-page reply that they want to submit in further support of Blake Lively's motion to compel discovery from Jed Wallace and Street Relations Inc. So she wants to address 2 discrete issues. I will just see if I can share it. I don't want to read through the whole thing to you if I can help it, because this is supposed to be a speeding through today. Let's just see, which one is it? There's that bloody many of them. Right, okay. So she wants to address 2 discrete issues. Where do I blow it up for you? When I've got this open, I can't see anything. This is not my main computer either. It's the one that I usually just use for Zoom meetings, not actual physical working on. So I struggle to know where, and then Zoom hides things on me as well. There it is. Right. So she wants to address 2 discrete issues newly raised in the Wallace defendants' opposition. You lose track, don't you? Because now it's like opposition to the motion to compel to. It's like, I don't even know anymore. So after weeks of conferrals, Wallace is claiming for the first time that Ms. Lively's motion to compel is untimely, given the court's initial date for party motions to compel, and unnecessary given that Street could have been made available for deposition testimony. And I noticed not actually, Golden was saying yesterday she'd never known this aspect of it, that Jed's deposition didn't get taken. But I remember, and I'm sure many of you do too, that she kind of ducked out of it. He made himself available, and it was all set to go. And then at the last minute, she said no. So it begs the question, why does she want all of this discovery when she didn't take the opportunity to get him deposed? And even if she decided once that it wasn't a good time to depose him, why didn't she kind of defer and do it again? So this is kind of her argument to that. And it's like 6 of one and half dozen of another, isn't it? But it's like, I think his argument is that if you'd have just deposed me, all of this would have made sense to you and you might have gone away. I have a kind of a feeling that in a way she's not really wanted Jed in. She's forced to poor Blake is forced to have Jed in this, because almost without it, she's no case at this point. But at the same time, she never wanted him in the case. She kind of did it by accident. And then that triggered another lawsuit in Texas because of the damage to Jed Wallace's reputation and physical health. So I wonder at the time, and maybe her attorneys were a party to that as well, that they didn't really want to know what Jed Wallace had to say in person, because would that actually thwart the argument entirely? Would it blow the case up at that level? And they'd know they couldn't go any further, and the client would know that she had nowhere to go either, and it all goes away then at that point. Is that what the fear was, either on Blake's part or the attorney's part? That I want to sue these people, but I don't actually want to know anything that will defeat what I believe to be true or what I want to be true. Was there an element to that in it? Because why wouldn't you just crack on and make him sit for his deposition? I think the argument here is going to, I've not gone through it properly. I assume the argument will be partly to do, well, we needed that information before we could depose you or something like that. So let's just run through it. But basically, I feel like Judge Liman, whether you're going to kick out, Blake's argument about compelling him to neuro. It's like how we had with Perez just now. I believe Judge Liman already knows whether he's going to kick Jed Wallace out of this case. So why the delay? It's like, from whatever they've presented to you, whether she's presented enough to continue compelling him to the Southern District of New York jurisdiction. So why delay? And I feel like that is reflected in what's happened to Perez now. And I know bits of that was entirely frustrating about Megyn Kelly now coming out and saying, I was subpoenaed too, I've beaten it, or whatever, how dare she, and the rest of it. But it's like, I guess Blake is going to want to hang on to Perez for dear life, because he might be the one that people would most question intention-wise, I don't know, or whatever it is. But I think he would be seen as an easy one to get information out to as well, to affect a narrative as well. So maybe she thinks he's the main key, Perez, and he's the easiest to get to and the rest of it. But it just kind of shows you the grandiosity when she would go after people like Megyn Kelly and Candace Owens and people like that she knows are very forthright, very free in their views, not afraid of anything, not afraid to ruffle feathers, that she thinks she can subpoena those people and will get what she wants as well. I think it just kind of continues to highlight the disconnect in Blake's mind over all of this, I think, or whatever argument is being put to her, that this is a good way of going about it, basically. So the Wallace defendants conveniently gloss over the fact that Ms. Lively attempted to confer with the defendants regarding their discovery deficiencies even before filing her second amended complaint. The Wallace defendants were going to be the first deposition way back when. So they refused to do so until they were added back in as defendants. Well, that kind of makes sense, doesn't it? Because why would you be deposed when you weren't a defendant? So thereby necessitating filing this motion within the court's second deadline for party motions to compel. In the same vein, Ms. Lively also has been unable to take the deposition of Mr. Wallace or anyone at Street Relations as a result of his unavailability, thereby causing postponement of the Street corporate deposition. This court should reject the Wallace defendants' efforts to deflect and evade their discovery obligations and compel the discovery as sought in Ms. Lively's motion. But he would have been deposed long since if they'd have just cracked on with it when he was first in the case, before he ever got kicked out. He was the one, at some point, he must have volunteered himself to be the first one to take a hit and do the deposition. And she was the one that went backwards on it, because it might be argued that they had nothing to put to him. So they needed all this time and all of this delay and all of these subpoenas to try and come up with bloody anything they could ask him in the first place. As Blake herself admitted during a deposition, she's not aware of one article that he's either authored or been in charge of, or even one article that has really bothered her, that must have been the source of something. She can't even identify an article she has seen in print and gone after specifically evidence attached to that, where she thinks it's done her damage. She can't even come up with an article that's really bothered her in that way, that she thinks this must be created by such and such. Let's have our investigators go after it. Let's get the discovery on that. Let's find out who wrote it, who got paid for it. None of that. So Ms. Lively's motion is timely. So she says it's keeping with the court's schedule in recognition of their non-party status between July 16th, when they were dismissed from the case, and July 30th, when she filed a second amended complaint re-adding them. During that time, the Wallace defendants confirmed that they would not be responding to Ms. Lively's discovery demands, and later declined to engage in any discussion regarding discovery deficiencies, because Wallace claimed that they'd provided everything long ago that had been asked of them, and they'd drawn a line under it that said that was that. So given that they were revived only once the defendants rejoined the case as parties on July 30th, and in light of their refusal to meet and confer in advance of that event, it was effectively impossible to meaningfully meet and confer regarding the Wallace defendants' discovery obligations within 3 days of the August 4th deadline. But the thing is, all adding them back in was just to bring in supposedly new evidence that she'd been able to find that would tie him to New York. It wasn't about getting further discovery materials off him. It was about her being obliged to prove why he should be in New York jurisdiction. And all she came up with was those vague Instagram posts, and that somebody should know, somebody should assume that because they know this about her, and somebody should know that because she was photographed here on that day, and that means because you were watching my shut socials, you should know that that ties you into New York jurisdiction. It's not about let's get more information from Wallace to prove our case. The whole point of her second amended complaint was to prove why Jed Wallace should be in New York jurisdiction. And instead, it's like, I want more information. I want more information. So you can understand his perspective of why should he? Why should he go to any more trouble? The case has already been bounced once on what they gave her, or the jurisdiction element. But basically, he's like, well, why should I give you any more? Because the jurisdiction element's just going to come back into play. So until that's, I can understand his perspective, but until that decision is made, why should I give her anything else? So indeed, upon rejoining the case, they didn't provide any response to her July 14th deficiency letter, take any steps to meet and confer, or otherwise suggest they viewed August 4th as the operative deadline. In setting the motion to compel schedule, the court expressly recognised that parties must continue to meet their responsibilities to confer in advance of motions practice. But I guess he thinks he's done everything. Let's just have a look. The court set a schedule for a second round of party motions to compel to account for the remaining discovery requests that were not ready for resolution by August 4th deadline. Ms. Lively and Wallace defendants were able to satisfy these responsibilities in advance of their August 22nd filing. Since filing a second amended complaint and to avoid the need for motion practice, counsel for Ms. Lively and the Wallace defendants have engaged in extensive conferrals regarding a discovery request, including multiple calls and numerous exchanges of correspondence, which also addressed RFPs 10 and 11, and which Ms. Lively could have moved to compel even without the proposed modified narrowing. She's so good, is Blake Lively. She's so kind all of the time and so accommodating in these letters. It always bangs on about, you know, how willing she is, doesn't. Oh dear. So they never objected to this timeline for motions to compel or seek clarity as to how it would affect them. So they never protested ECF number 553. Ms. Lively excludes defendants Jed Wallace and Street Inc. from this motion because the time to confer on their responses and objections to Ms. Lively's served discovery and their deficient productions was cut short given their dismissal. she filed an amended complaint, re-adding them, and will move to compel them if necessary by August 22nd. I guess that's what she's doing. Their interrogatory deficiencies are not excused by deposition testimony. So the Wallace defendants argue that interrogatories 13 and 14 do not warrant a response, including because Ms. Lively can obtain this information through a deposition of Street, which they accuse Ms. Lively of unilaterally cancelling roughly a week before it was scheduled to take place. Federal rules of civil procedure entitle a party to written discovery and deposition testimony, with written discovery often sharpening the questioning for testimony when it takes place. And I think that's the problem, isn't it? It's like I said, they didn't really have anything to ask him based on what they had so far, so they needed more and more and more. Far from a matter of simple credibility where exclusively deposition testimony might be appropriate, interrogatories 13 and 14 seek substantive responses, and Lively is entitled to obtain that through all discovery tools available, including interrogatories and depositions. Ms. Lively should not be precluded from straightforward discovery responses because she also intends to obtain party testimony, and the Wallace defendants' responses to these two simple interrogatories will be useful not only in the eventual deposition of Mr. Wallace, but also in connection with several other depositions relating to these issues that will take prior to his deposition next month. So he is going to be deposed according to this then. She's not waived her right to receive responses to her reasonable discovery requests because she rescheduled a deposition of Street's corporate representative is baseless, suggesting that Ms. Lively's motion should be denied because she missed her chance to take the deposition that could have addressed her concerns. This fails to recognise that a party may reasonably sequence and arrange depositions from within the discovery window, including postponement where necessary, and with sufficient notice, as was the case here due to delays in the third-party productions of Case and Coslow. It's everybody else's fault, isn't it? So mere days before the scheduled deposition, Wallace's counsel informed Ms. Lively's counsel for the first time, after declining to provide the information when initially requested, that Street intended to have a paid outside consultant sit as Street's corporate representative, despite the fact that Mr. Wallace is the only director and officer of Street. But that makes sense to me, that you might have somebody do that, because if you're being an entity and a person in a lawsuit, it kind of makes sense that you might want to separate it out to me. You know, like how you might have pay an independent investigator to do a HR investigation for you. I would imagine that to some extent and purposes, it's kind of trying to appear at least to be above the board, isn't it? Paying somebody else, an independent person, to do it and testify on the behalf of that entity, even if they didn't know anything about it previously and they just had to research it or be provided information or whatever it is, or investigate for themselves. So, of course, a consultant who has never worked for Street would be unable to provide thorough testimony on the background and the covert roles and responsibilities of the Wallace defendants, particularly when that consultant was prepared by Mr. Wallace, who at the same, well, Mr. Wallace will be prepared by Mr. Wallace, won't he? Who at the same time was unwell enough to sit for his own deposition. Well, that's the thing is, I would imagine Jed Wallace will be quite happy to provide his medical records to the judge to prove what Blake Lively has been putting him through. We're already aware of some of it, the impact on his heart. The consulting option would only be appropriate at most if no one directly affiliated with Street had the necessary first-hand knowledge. But here Mr. Wallace does case law there, which says that the deponent must make a conscientious good faith endeavour to designate the persons having knowledge of the matters sought by the party noticing the deposition. Well, have they asked what knowledge this guy will have, or what connection or what experience he may have? I'm guessing it's not Johnny off the street that he'd get to talk about present a legal argument on behalf of his company. Um, More case law stated parties stipulating to designation of non-parties as corporate representative when the parties agreed that no person currently employed by the company had first-hand knowledge of the designated topics. Given the circumstances, Ms. Lively's reasonable choice was to forego this early discovery in order to secure competent testimony from Mr. Wallace as someone affiliated with Street. This sequence of events only proves the point. Miss Lively should not be deprived of fulsome responses to her written discovery, particularly in light of the Wallace defendant's anemic document production. Well, here's an online business. It probably doesn't have a lot in paper. While she waits for Mr. Wallace to confirm his availability to sit for his long-awaited deposition, as if she's been waiting for it forever. For the above reasons and those in Ms. Lively's opening brief, Ms. Lively respectfully requests that a motion to compel with respect to the Wallace defendants be granted in their entirety. So that's what they are wanting to, this permission for this 5-page thing to be brought into play. It's exhausting, isn't it, all of this? So I don't want to touch too much because so many people will have been commenting on so many things. Let's just briefly look. So Paul Case and Coslow, Catherine Case and Brianna Coslow, they are now having to have this in-camera review of some of the productions under question that they say is protected and privileged, and Lively says maybe compelling for her case, and she doesn't believe the privilege necessary. So they're having to have this in-camera review, which is basically just means in person. It's just another Latin legal phrase. So basically they have to produce these documents to the judge for him to go over them and for him to decide on a document by document basis whether any of them have relevance and are not privileged. Basically, so that's what's going to happen now. So that was just from their attorney saying that they'd provided an expanded and revised privilege log to further clarify the limited scope of materials withheld by our clients, Catherine and Brianna, on the basis of attorney-client privilege and attorney work product. So it breaks it out on a conversation by conversation basis, where each conversation represents a 24-hour period of messages. In light of our provision of this information, we would not oppose Ms. Lively submitting a reply in further support of her motion, taking into account the clarified information present in this privilege log. And the upshot of that was she said, F that, well, I want an in-camera review. And the judge has given that to her. So this is their privilege log that they've submitted basically. So let's just have a little quick look. I'm obviously not going to run through all of this. So you can see it starts kind of back from August 23, 2024. And this is Catherine Case, and I believe this is to her father. So Blake wanted this, but James Case is an attorney. So obviously Katie, Catherine, went to her dad to get some advice on how, you know, that she was going to be dragged into this thing. How should I proceed? So, you know, so it's a text message thread reflecting a discussion of employment law issues and coordination of potential counsel regarding same. And then August 28th between them again, follow up on past conference call discussion and related legal issues. So then you jump to December 21st, 2024 between Brian Smith Benson, Brianna, Melissa Nathan. So most all of these start with this text message thread reflecting communications with counsel and individuals sharing a common legal interest regarding legal strategy and connection. They more or less all start with those words. And that was about the Jones lawsuit prepared in the course of an anticipation of litigation and for the purpose of obtaining and providing legal advice. And, you know, it's interesting, isn't it, how Blake is pushing for all of this information from early August, sort of even before the premiere. But the thing is, if these people were going to be doing dodgy things and we're going to have conversations about it. They already knew in early August, if not way before, that there was a good chance this was going to go tits up and Blake was going to sue them. So why would they be communicating in document form or anything that could be legally compelled if they had any ounce of brain about them and they were already suspecting there would be litigation? There wouldn't be evidence of it, even if they had done it, would there? Or there'd be very, 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 very little. Whichever side you want to believe, these would tend to be smart people, I would think, was what ran through my head. So, so it just shows you, done it. Christmas 2024 was crap, crap all round, wasn't it? Boxing, people, James Vituska was messaging people on Christmas Day. This is Boxing Day here, December 26th. Legal strategy, related updates in the course of and in anticipation of litigation. Many of Blake's arguments is that they shouldn't have been preparing for litigation as early as August, but they'd been the people that were dealing with her. I think they had a fairly good idea even in August when she started unfollowing people and there started to be speculation that people would be speculating stuff, and any kind of speculation in that environment will often lead to a lawsuit, won't it? So why she thinks it's unreasonable of them to have been seeking legal advice as far back as August, it just beggars belief to me. So it's a lot of the same things, I believe. It's all about, obtaining and providing legal advice. I guess Blake's problem is that it's between attorneys and TAG, or attorneys and Jen Abel, or attorneys and Jed Wallace. But so her argument is that it's not about coordinated legal strategy or them having a shared interest or anything like that. She's looking for anything that can separate them all up and give her an in, isn't it? And a lot of it is to do with the New York Times lawsuit as well. So that's often mentioned in these. So this is all what's going to come in front of the judge for him to decide on a document by document, conversation by conversation basis. No idea what that dog's doing. So I don't think there's any point going through all of that, but that's basically what that's referring to. I think Case and Coslow are the two that have come off kind of almost the worst in this, because with the best will in the world, they are the underlings, you know what I mean? They're not the bosses. And they've had to do an awful lot in terms of this lawsuit. So that is Jed's response. Defendants Jed Wallace and Street's response in opposition to plaintiff's motion to compel discovery. So this is prior to what I started with at the beginning. How many pages is this? Oh, it's 16. Lively's motion to compel is long on rhetoric, short on substance. Faced with the inconvenient truth that the Wallace defendants played no role in any alleged smear campaign, Lively now seeks to create discovery that simply does not exist and never has, or to otherwise engage in a fishing expedition to flesh out an empty narrative. So I guess this I imagine that what I started with at the beginning is in response to this here. Lively's motion is not a bona fide effort to obtain necessary evidence. It is an attempt to rewrite the script because the controlling facts do not support her narrative. Having already missed her chance to take the deposition that could have addressed her concerns, Lively cancelled the early July deposition of Street that was to be the first deposition in this case by agreement. And actually, that was a brave move by him, really, and you would have to question. My dog is doing mystery things, probably involving destroying something of mine. But yeah, I think you've got to give him props for that, because it's a big deal to be the first one deposed when you're the one that's being accused of being this kind of mastermind of a smear campaign, because you're having less chance than anybody else to come up with a story. Etienne, what are you doing? Oh, she's eating dog food. She's allowed to do that. She's probably been rubbing her nose on the rug for about 5 minutes prior to deciding to finally eat it, objecting to it not being special enough. So yeah, I would give him props. I keep getting little flashes of admiration for Jed. I'm not saying that he may or may not do dodgy things on behalf of people, but I think he's kind of yeah, I think you'd have to say brave for want of a better word. It because I feel like it's not up to now when he kind of is saying he's had enough and he's saying I'm not providing you anymore. You've had it. I've already been dismissed out of it once. You're trying to get out of my lawsuit. Why should I give you any more? I'm not going to give you all of my work product history in order for you to concoct something that you can hold me to this lawsuit with when I haven't done it in your case. I feel like that is his point of view. And up to that point of him putting his foot down now, I feel like he has been pretty upfront and he's got on with everything. He volunteered to have the deposition first. He's completed what he considers to be his deposition, his discovery obligations way ahead of time. I think he is the one out of anybody that seems to want speed and to get this over with so that he can get back on with his life. I think he's had a huge it's been a huge impact on him, and his role in it all, I think, has been quite minimal, really. Like we said, she's not proving this massive smear campaign. She's focusing a lot on this idea of he was paid $30,000 a month. That is nothing in terms of if he was doing what he was allegedly she wants him to have been doing, he would have been being paid an awful lot more. That's like kind of peanuts to these people, isn't it? $30,000. $30,000 is sitting on it and monitoring it and giving a few suggestions. It's not like having an army of people sat on every comment on the internet and an army of bots and trolls and troll farms and all the rest of it. You're not talking $30,000 a month for that, I do not think. Lively now turns to motion practice as a substitute for diligence. The proportionality mandates of Rule 26, the court's scheduling order, and basic notions of fairness all foreclose this tactic because the requested materials do not exist, are outside the permissible scope of discovery, or are protected by privilege. The motion should be denied in its entirety. I think this is where the judge bothers me, because we already know he's told Jed in the past that he has to give up his client list and his methods of what he is capable of doing, if you like, or what he has done for others. But at the same time, he's been dismissed out of this case. So it's like, this annoys me because I feel like the judge should rule on the jurisdiction issue without delay. Because why should he have to do anything if he can't be held to the bloody case? It's like the Perez issue, isn't it? If jurisdiction cannot be proved, it goes away. It goes back to wherever it's supposed to be. It's like Jed Wallace is happy to fight this in Texas with Blake Lively, where it belongs. So it's kind of frustrating to me that the Liman thing. I'm glad he came out and he did what he has done to Perez and kind of acknowledged that he made a good job of arguing his case and all the rest of it, and successfully managed to evade tying himself into jurisdiction in New York accidentally. He's acknowledged all of that as the judge. But at the same time, he tortured him for long and long enough when he could have just said, this isn't my jurisdiction, very early on. And it's so frustrating, if you allow yourself to be frustrated, which we should not. The record establishes the Wallace defendant's limited involvement in the events underlying this litigation. Street's engagement was confined to monitoring social media and advising on public engagement, all remotely from Street's and Wallace's rural Texas location. So they fully complied with the discovery obligations under federal rules of civil procedure, producing all non-privileged and relevant documents in their possession, custody or control long ago, with a small production going out this week based on the meet and confer efforts to date. The limited number of documents, and even Blake admits that they've still been conferring in what we read at the beginning. The limited number of documents produced by the Wallace defendants does not reflect deficient discovery efforts, but rather is consistent with their limited role. a point underscored by Lively's testimony that she cannot identify any publication attributable to Wallace or Street in the context of the so-called smear campaign. Lively served the Wallace defendants with several discovery requests on March 14th and June 4th, to which the Wallace defendants timely responded. Unsatisfied with the reality that the facts do not conform to her version of events, Lively resorted to accusations of deficient document productions and discovery responses, including going so far as to complain of the Wallace defendants' failure to produce documents or provide information they simply do not possess and never have, or that does not exist and never has. And it's like in that deposition testimony, she knows nothing about him other than through word of mouth, was what she implied during that deposition. What people have told me, that he can do clandestine things. And how many people in life have been accused of being mastermind, of having like magical levels of sorcerous spells at their fingertips, that when it's all come out, it's just been a lot of hyperbole and Chinese whispers and all of the rest of it, that people don't have these magical powers, but you can make anybody be anything if you want to have that narrative. You know, it's, you know, nothing. I don't know. I'm not an expert, but I don't. These people that do have these kind of businesses can say all they like that this is untraceable. There'll be no fingerprints. There'll be no this, that, or the other. We know that's impossible. I think, I believe, from other people that I've spoken to and other comments that I've read, is that nothing you do on the internet is untraceable. And we have Justin himself saying that I don't want bots responding to posts about me. I don't want bot support. You know, so if he doesn't want bot support or bots doing things to her, he's certainly not going to want worse to be done to her and things that look even more false, is he? So, you know, I mean, over this idea of Wayfarer now have to produce documents above and beyond and up to February 18th, maybe some things are going to come out that don't paint them in the nicest light, or there'll be conversations out of text, you know, out of context, where you can't see people's faces, you don't know the tone of voice, you don't know if there was any humour to it. Who knows what's going to come out? But I don't think it'll change the underlying facts of the matter. It'll be interesting to see what comes out. I think it's entirely unfair. One of my main problems with this judge is this idea that when there's these arguments of, well, you know, you've got the two parties, whichever party it is, whether it's Jones or Wayfarer or Wallace or whoever, Case and Coslow, whoever's going on, it's like there'll be an argument about, we were doing this and they could have said at that point that they needed this. And the other side will say, yeah, but blah, blah, blah. They'll have the exact opposite argument over, yeah, but they could have done this. And it's like a circular argument, isn't it? Because both sides are right and both sides are wrong. And we all get into these things in life where we could have done and should have done, but they could have done and should have done. So at that point, how does the law make the decision that one side is right and the other side is wrong? But the judge keeps doing that, and he keeps doing it on the side that isn't the Wayfarer party's side. I do find that he keeps giving the benefit of the doubt to the plaintiff's side, or the Steph Jones side even. Now, I don't know what that's about, whether that's when it is the plaintiff that you have to give them more benefit of the doubt because they're the ones trying to prove a case. I don't know. But the defendants the defendant's role in any case is to make it hard for the plaintiff to make a case against them, isn't it, really? And to be objectionable within the letter of the law, I guess. You don't want to give it anything to them on a plate, do you? But yeah, I do find it really frustrating that Liman keeps, it's like this idea of, Blake blanketly said she did not want to provide search terms for how she came up with giving Wayfarer documents. So without knowing what her search terms are, which could have been anything, it's, you know, that didn't involve Taylor Swift, that didn't involve, you know, SH or whatever, or or conversations with Ryan. Or, are you going to be all right at work today, love? Do you need me to come in case he like touches you inappropriately or kisses you too long? What has she bloody provided them? Would be interesting to know based on the search terms that she's agreed on for herself. And she doesn't have to say what her search terms are, but Wayfarer have to say what theirs are. And that was an argument. Like the judge goes, Wayfarer have not adequately said why they should not provide search terms, and saying that just because Lively said she's not going to provide them does not mean that they get to say similar. So that is one of my main frustrations with it. And I kind of a little bit of frustration with Wayfarer's side that at this point in time they haven't caught on to the judges like this, and that basically for everything it's never any good to say, well, we're not going to do this because they're not doing this, or they didn't want to do it, so why should we have to do it? Because they should know by now at this point that judge expects to have case law cited on everything to do with anything like that. He will not just take it that because they haven't done it, we shouldn't have to do it. He's not interested in that at all, Lyman. He's like neurotic about case law and having proof of why this shouldn't. And that's what's kind of frustrating reading Lyman's replies to such as compelling them to now give up discovery to Feb 18, is that I'm losing my train of thought again. Where was I going to go with that? But yeah, that's what I was going to say. He kind of makes it sound as if they haven't even tried to say why they shouldn't do certain things. It's like they've not really argued this and they've not really argued that. They've not even bothered trying to address that. And it's like, did we read the same thing? You know what I mean? It's a bit like that, isn't it? And it's like Wayfarer now at this point should know that that's how the judge goes about these things. So they need to be hyper on it whenever they're producing anything that's about why they shouldn't have to produce something. It needs to be case law, case law, case law, case law. They need to have, even if it makes it double the length of a document or something. Whether it's because they are writing it for public consumption, that may be it, maybe. Maybe it's because they are trying to make it readable to us and they are relying on people on social media talking about the documents and such. And the more case law is cited, the more unwieldy these documents are to read. Maybe that's an element of it. Why they're not making it more legalese. That could, and it's only just come to me now, maybe that's why it is, but it's also doing them a disservice, I guess, at the same time. I think it's probably more just the burden than anything and the frustration for Wayfarer of why should we have to give this woman stuff beyond when she filed the CRD, when she commenced this lawsuit, whatever it is. She cannot just keep saying this is going on forever and a day. And at least the judge now at this point has pointed out, the more you try and prove this by elongating it, the less likely it is going to get, and the less likely you're actually weakening your own argument. I guess he's trying to get across to her that who in the right minds would be still doing an ongoing smear campaign on you when they're in the active midst of a lawsuit. You know what I mean? But I just don't think Lively. I think you'd have to hit her over the head with it for her to get it, and then I still don't think she'd get it. So during conferrals, Lively's counsel failed to raise issues now before this court or provide the Wallace Defendants Counsel with meaningful time to consider proposed discovery modifications as Lively raised against this court's deadlines and did so unsuccessfully, filing an untimely motion. So in that I read at the beginning, she's trying to say that it was timely and that she got it in within the right limits. So FRCP permits discovery of any non-privileged matter that is relevant to any party's claim or defence and proportional to the needs of the case. The party moving to compel bears the burden of demonstrating both relevance and proportionality. The rules do not require the producing party to search for potentially relevant dockets indefinitely until the requesting party is satisfied that, as here, nothing else exists. I do like Jed's lawyers, I must admit, Jackson Walker and Co. They are very good, I think. So there it's going into that it's untimely. I don't really think we need to go into all of this. Lively filed this motion 3 weeks after the court imposed deadline and over 4 months after the defendants responded to Lively's first set of interrogatories and over 1 month after the defendants responded to Lively's second set of interrogatories and RFPs. Even though the court granted the Wallace defendants' motion to dismiss on July 16th and provided Lively leave to amend, which she did on July 30th, the prior court order applied to all discovery currently outstanding, including interrogatories, RFPs at issue here. Lively provides no justification for a delay, ignoring the deadline entirely. I don't know whether they'll get away with that kind of thing. There's so much this judge just goes la la la. Just, I don't know. I don't pretend to be an expert. He doesn't seem to like arguments about dates and compliance and things like that. I think he just likes to slap people's hands. It's this business of you could have, they could have. I'm going to just pick a side arbitrarily, and you might not like it. You don't think that's what he does. Lively's motion to compel supplemental responses to interrogatory 13 and 14 should be denied. Lively asserts that Wallace refused to respond or to provide a credible response to 2 interrogatories. Number 13, identify all former or current clients for whom you have performed services similar to those provided to or on behalf of any wayfarer defendant, Brian Friedman, Lina Friedman, or anyone acting on their behalf, including without limitation efforts to seed, influence, manipulate, boost, amplify, or engage with social media algorithms. Who wants to bet that Blake Lively goes to bed and in her mind, if she's struggling to sleep, she has like sheep jumping over a fence going bots, troll farms, seeding, manipulating, influencing, boosting, amplifying, just to lull her off to sleep. So yeah, blah blah blah. Engage with social media algorithms, narrative of virality, as well as the use of bots or inauthentic accounts, which Justin himself said, as I said earlier, I do not want bots saying anything in support of me, basically. I don't want bot comments. Interrogatory number 14, identify all employees, associates, or subcontractors who have performed services for you since May 1st, 2020. May 1st, 2020, including to seed, influence, manipulate, below, as well as the use of bots or inauthentic accounts. 13 is not proportional to needs of this case and contravenes the court's order concerning Lively's efforts to seek the same information in the context of the corporate representative deposition of Street. In its July 7th order, this court delineated the relevant scope of information relating to Street's clients. Lively seeks to understand whether Street has engaged in campaigns for other clients similar to the campaign alleged in this case. If Street Relations has participated in digital campaigns for other clients to harm the reputation of third parties, it is more likely to have done so here, as Lively alleges. And it's like, who defines what is a similar campaign? Because I think we're seeing with this lawsuit that we've not seen anything like this before. So it's like, who determines that, I guess? So docket 390 at 2. But Lively did not narrow her interrogatory accordingly, instead seeking more without any showing of relevance or proportionality. I'm not going to go into all of that. So Lively's interrogatory, to the extent it can be understood, goes beyond seeking identification of clients for which Street has participated in digital campaigns to harm the reputation of third parties, as Lively alleges, to which the answer is none. I would imagine that many of Jed's clients, when they come to him, I would imagine it's nearly always about promoting them positively rather than going after the other person, because it's more dangerous going after the other person, isn't it? You're more likely to get found out and you're more likely to encounter further litigation or litigation where there might not be litigation. I would imagine that most people that come, it's just to get a positive light shone on them. Maybe I'm being naive there, But I would think that for most people, they would just want amplification of any positive content about themselves, organic or inorganic. But rather than going after somebody else, I would think that would be far less sensible in a way. So he says he's got his answer there was none, wasn't it? It's a one-word answer that he didn't have any of this stuff. Nothing to do with participating in digital campaigns to harm third parties. Lively would know this had she not unilaterally cancelled the scheduled corporate representative deposition of Street a month and a half ago and just 6 days before it was set to proceed by agreement. Lively's motion to compel them to supplement the response to 13 should be denied. Alternatively, it should be narrowed to reflect the prior court order. In her motion, Lively incorrectly identifies 13. The correct interrogatory is copied here. And then 14 is an expression of frustration that she does not like the answer she received. Indeed, Lively claims entitlement to probe the Wallace defendants' representations in response to 14, in which the Wallace defendants answered under oath and verified that the only employee, associate, or subcontractor performing services for the Wallace defendants from July 1st to December 20th regarding the project beginning August 9th, regarding it ends with us and it's 2 stars, Lively and Baldoni, is Jed Wallace. And the thing is, they can argue teams and bots and farms and all the rest of it as much as they want. Anybody in a professional environment, it's like anytime I ask ChatGPT for something related to my company, it annoys me because it comes back with we, and because that is the way of business, isn't it? To even if you're a solopreneur, to imply that there's a team, that there's all these people on you, it's like normal business practice, really, to make yourself sound bigger than you actually are. But Lively's unhappiness with the answer and allegations of credibility concerns do not warrant the relief she seeks. To the extent Lively has questions regarding, if he had a ton of people working on this, it would have been more than $30,000 a month. There'd have been all those wages to pay, all those computers, all those rental properties in Hawaii or wherever it was supposed to be, you know, all the rent paid out, all the overheads, all of the rest of it. Can you imagine? To the extent Lively has questions regarding the Wallace defendant's credibility, those questions are best explored during a deposition, not through expedited motion practice. Yeah, I think you get, and I think that's what I'm saying over Jed and his attorneys. I do think you get the sense with them that they just want to get through it fast, deal with it, don't stall, get it done, get a ruling, move on, get on with your life. And that's what I kind of like about his attorneys. There's not that same sense of shilly-shallying that you get with Blake's lawyers. I don't think they don't want to do it over endless documents or endless meet and converse. It well, like, you should have just had your deposition and this would have been done. I just want dismissed out of this case because I shouldn't have to answer this, basically, isn't it? You know what I mean? It's a bit like that. I think they're keen to get on and deal with it in Texas myself and get it properly sorted out. So she could have explored the credibility concerns she now claims at length during the previously scheduled deposition. She could have actually got to know him during the deposition if she'd have sat in on it. She could have seen for herself whether he seemed like he was this clandestine figure. She could have whispered in her attorney's ears and said, ask him what he does that is so clandestine. Or, you know, why do people describe you as clandestine? Why have you got this reputation? She could have come up with all sorts of things if she, but I kind of think she didn't really want to know. It kind of gives you this false sense of security, doesn't it? If you don't deal with somebody in person, you know, if you only know them through email. It's like many people these days don't want to do phone calls, do they? Or face-to-faces. They want to deal with their lives through email because you get that distance. While ever she was only dealing with him through documents and productions, she didn't have to face the idea that she didn't have a case or that he wasn't responsible for what she thought he was. I think there's an element of that to it. And I think that's the thing for Blake. The longer it goes on, the more reassurance she gets from it in a way. You know, it feeds into this narrative of this is highly secretive. It's really hard to unpick and unravel. They're so devious, these people. Whereas if she deals with it head on and just sees that this guy is nothing, it's like it all goes away, doesn't it? And then she's to deal with the repercussions and the consequences. I think there's an element of that to it. How long have I been talking for? Right. I wasn't going to go through these at length. So I won't do. I just don't want to miss anything that might actually be interesting. So Wayfair now have to produce any signal communications that they have, and because this is a disappearing message platform, or from what little I understand, it's you can set it up for the messages to disappear after a short time. I don't know how they produce those unless they have to go to the company or have them forensically extracted in some way. If they have disappeared any communications, just as a matter of course. So Wayfarer now have to come up with any signal communications. And there's been bits and pieces that have come out already to do with signal. And he says here lively, unhappy with that truthful response about signal communications because they don't possess any, they're saying. She now demands an impossibility that this court compel the production of non-existent documents and communications. Lively acknowledges that signal includes ephemeral messaging capabilities that delete the content of text messages, which is dispositive of this dispute. It's just because it's capable of that doesn't mean they did it. And how do you prove that they never existed in the first place? That's the difficulty, isn't it? And she's chosen to accept it by the looks in certain interrogatories that must be less important to her, that there are no signal communications in response to those. So in the face of a denial by a party that it has possession, custody or control of documents, the discovering party must make an adequate showing to overcome this assertion. Lively does not and cannot establish that those particular messages exist in the Wallace defendant's possession, custody or control. And I guess that's why this is going to be so important now, this excess information up to Feb 18th, that may flag up more instances of well, there should be a reply here and there should be a reply there or something like that, or maybe it will all become more clear. By operation of signal settings, any potentially responsive messages were deleted as a matter of course well before the Wallace defendants anticipated or received notice of this litigation. Kind of like I said, the minute they thought it was going sour, which was really the minute they brought Jed on, really, if you like, they knew they were going to be, it might turn litigious, so they would know that things would be compelled. So would they be trying to be seen to be above and beyond, above and beyond, I can't say it, above board. That's what I'm trying to say, combined with above and beyond. So would they start using a secret signal messages and stuff, knowing that there could be an accusation on them? Well, those will have been deleted. Would that have been the sensible course of option to start using signal? I don't know the answer to that one, but remember there was plenty of time where Lively was believing that they had kind of like some combined shared account somewhere where they all had access to an email account draft folder, and they were all answering each other in the drafts folder and deleting the drafts. That was her accusation, if you remember, at one point. That was her point of view, and it's kept pivoting as Blake's point of view over how they were doing this, and the latest focus is these missing signal messages. She suggested they should have foreseen litigation as of September 16. The record and Lively's case law demonstrate otherwise. I feel like they must have known from him first coming on. I think the moment she deleted him off her friends, off her Instagram and stuff, and the press started, you had to know at that point that there's a good chance something was going to happen, wasn't there, really? I think those dates don't mean anything, really. although they are saying they had no objective reason to anticipate litigation until December 20. I don't think that's entirely true there. I think it's there for the legality of it, but they must have thought earlier than that. Leaked to the New York Times, duty to preserve those messages. Blah, blah, blah. So just more case law cited to do with messaging. So it's saying the Wallace defendant's signal messages were automatically deleted before receiving any notice of Lively's claims as part of the regular business practice in place. But my feeling was I don't know. I won't go into that too much further. I don't honestly think there was this massive conspiracy to have these big clandestine conversations on Signal somehow between early August and December. Because like I say, if you thought you might at any point be looked at, you don't want to be having some secret clandestine messaging service that was deleting your messages to being seen to be using it. Really, does that make sense? I don't know. You tell me what you think. The court will recall that Lively alleges in the CRD that Wallace and Street sexually harassed her, which would be difficult to do since they have never met, meaning they never could have anticipated litigation of the sort alleged by Lively. Yeah, that gets forgotten, doesn't it, from time to time, that she put his name in that CRD, which we believe was an accident. She got herself into that. So, la, la, la. That's just more about a third party that deactivated the Google Analytics shortly before the notice of the plaintiff's potential claims. Right, okay. Here, Lively fails to provide any evidence suggesting that the Wallace defendants are not being honest about the auto-deletion policies applying to any potentially relevant Signal chats. And the thing is, it might have just been like, like how you set up a family group chat or whatever. It might have just been a chat set up for that, where they were just bantering backwards and forwards or giving each other a pep talk or whatever it was, or just saying, have you seen this? Have you seen that? What can we do about this? They might not have wanted to keep it long term. It might have been as innocent as that. It was just used as what might be called a broadcast channel, if you like. Just an open comms line, like the bats, like the bat channel or whatever. Bat phone. Right, okay. Don't want to keep you too much longer, and there's still a couple of things to go through. Defendants' post-litigation internal communications are protected. Where he thinks Lively is simply not entitled to the discovery that it requests. So he's saying kind of he got counsel somewhere in December 2024 after Lively filed the CRD and leaked it to the press. So she can't have work product production. So she can't have access to their strategy, basically. So she doesn't make an attempt to demonstrate relevance or that they're not privileged. La, la, la. So Lively's demand for a privilege log of all documents withheld after December 20th, extending to the present, should be rejected. I'm not going to go into all of that. Defendants had no opportunity to respond to Lively's last-minute suggestion regarding RFPs 10 and 11. While the Wallace defendants do not admit at this stage that responsive documents exist to RFPs 10 and 11 as modified, they had no opportunity to confer with Lively regarding these modifications. Lively paints a picture that the Wallace defendants simply declined to respond to counsel's suggestion, but Lively admits that she provided the Wallace defendants counsel with this suggestion within hours of filing a motion. The court should decline to address this dispute until the parties meet and confer. And the thing is, remember as well, that whole second amended complaint was very much timed to not give them time before her deposition the following morning either, wasn't it? You know, which was, it's just not good tactics, is it? It's not fair and above board, is it really? And Babcock was Jed's attorney that was at the deposition as well. And he subtly raised, oh, it's a big old document, this, isn't it? I haven't had time to go through it, but I just redlined a few items. It was very good. Even just from that like snapshot of the deposition, you got a good sense of him, kind of thing. So that's basically Joel Glover on behalf of Jed. Yeah, it's just more or less, it's just like the motion to support what we've just been through. Despite the great time and expense dedicated towards prepping the July 9th corporate representative deposition of Street, which would have been the first deposition in this case, counsel for Lively notified me via email on July 3rd that they were cancelling it. So I guess with it being the corporate thing, that's whereby they instructed whoever was going to represent Street itself, the company, they'd put a lot of prep into that. Into making sure that guy knew what he was talking about, I guess, and had access to the information. So they're at 13, because we were no longer parties to the case at that point, I emailed Lively's counsel on July 16th, confirming that we would not respond to July 14th discovery letter. Yeah, I'm not going to go through all of that. It's pretty much just the same. It's just a snapshot of it. What is that now? Oh, what is it? Oh, I think this is just where the judge has gone through and said all of the reasons why Lively gets to have things through to the 18th. So let's just see what little comments I made for myself. What did I put here? Yeah, it's kind of what I said before. The way the judge writes these things, the Wayfarer parties offer only limited objections to Lively's motion to compel. They argue that they should not be required to produce. He hates that, doesn't he? That's what I'm saying. He hates when it's like, it's just like hyperbole to him, isn't it? They should not be required to know legal terms behind it or no citation, or should be required to do so only if Lively is as well. It's always, and my little comment is, it's always interesting how the judge always seems to say Wayfarer doesn't really seem to mind if Lively gets what she wants, as if they barely objected at all and want to do it, really. That's kind of what I said, isn't it? Let's just close that one off. Let's see if I've said anything else that's interesting or relevant. You can see why I left it a couple of days, because all of these documents were bombing in, and it gets really overwhelming. You know, I am not a team. I don't have anybody helping. When I stop this thing, I have to go mow my lawns, and then I've got a dog to bath and a client to prep for tomorrow and a house that will want cleaning after I've done all of those things, you know. And yes, I don't have children or anything like that, but I'm literally a one-man band, and I'm single and husband shopping, if anybody knows a good man, because I could do with some help. I'm open to offers, basically. So let's just have a quick whip through there, because you'll have seen this with other people. They'll have gone through it. Liman's response as to why Wayfarer has to make further productions, basically. Yeah, so this is like to do, third parties have produced documents in response to subpoenas from Lively that Wayfarer apparently should have disclosed but did not. For example, third parties have produced emails with Wayfarer reps containing phrases such as HR complaint and harassment protocols. So he thinks it's worth further investigating if there's anything else concerning those, basically. and anything to do with policies and procedures. Um, this was a weird one. Third parties have also produced text messages with Wayfair, including terms like "it ends with us." Well, if they produce everything to do with "it ends with us" with no further context, that's going to be a ton of stuff, isn't it? Because there's it'd be related to everything: marketing, promo, posters. How many times will that phrase be used in something? Um, a reasonably diligent search would have captured these responsive messages that cast doubt on the completeness of their searches. Lively is entitled to verify the processes by which the Wayfair parties have searched their databases for responsive documents. I really feel like Wayfair are entitled to know how she's searched, though, don't you? I feel like Wayfair must just have an entire lot of nonsense. I can't see what they will have been given by Blake. What the heck will she have given when she's literally chosen what she'll hand over? So Wayfair cited no authority for this idea of why should we provide our search terms unless she does? And that's the problem, is why didn't they cite an authority? They keep unless, like I say, unless they're writing it for us and they don't want to get too legal. Every so often they're going to have to remember they need to cite an authority for this judge, because he just does not get it. It's like I said from the start, he does not want to put two and two together or make he just doesn't want to do it. He just does not want to make any jumps of, well, if this happened, then that must have happened. And if this gets done, then so and so should have this done as well. He doesn't want to do any of that. So they need to provide their search terms because she has preferred specific evidence regarding deficiencies. She's proved well enough for the judge's perspective that there could be other things. So that's why she gets to have it to the 18th. So it basically didn't read very well, this, when I first read through it. And it was thanks to not actually Golden, really, that it brought it into perspective for me a bit, because you can get taken down when these come through, because it's so frustrating that it seems like for every time with Wayfair, it's denied in part, approved in part, isn't it? And the approved in part always seems very small, or the part that's on their side always seems like a very small take home for them, doesn't it? You know what I mean? But it was, literally not actually Golden pointed out that actually to have that cut-off date and for the judge to say this is not going to strengthen your case if it keeps going on forever, it's just going to look weaker. It actually was quite a good decent little win, really. And maybe Wayfair don't really mind giving over some of this stuff to Lively. Maybe they would have fought harder. Maybe they just think it will muddy the waters a little bit more, but won't actually hurt them as such. It might just mean they'll take a hit in the press of a few more not very well composed headlines, that send people off down the wrong rabbit hole or something. Maybe that's why they've stalled on some of these things. We'll just have to see and deal with it as it arises, which is what I always get told by people I've trained with about hypnosis. You can't plan hypnosis ahead. Don't let anybody, if you go to a hypnotist, don't work with somebody who's just going to spout a script at you, because they need to respond to you as a person with your particular metaphors that you use about yourself and the viewpoint you have on life. Like, it needs to be for you. We deal with what arises when we're good hypnotherapists. And it's the same here. It can apply to so many things in life. So that's it, really. Is there anything else worth mentioning to you there? Parties observed that some of Lively's requests have no apparent connection to any alleged smear campaign and therefore cannot provide a basis for continued discovery. Lively just really wants anything at this point that casts them in a bad light, really, as well, doesn't she? Any kind of derogatory things said about her, or it's all just trying to put two and two together and just try to make enough mud that they don't look so good at this point, Wayfair. That's all it is, really. So yeah, they didn't get away with the argument that a lot, and this again is the frustration. Because I think oftentimes the Wayfarer parties have been held to the idea of make sure this is worded in absolutely the correct way, because they've not got away with this idea that some of these RFPs were directed to just Wayfarer Studios and not to other parties, so that she can't, they were trying to say she can't have that information because she's phrased it wrong. But they've not got away with that with the judge. He's like, this argument misses the mark, because Lively noted that equivalent requests exist for the remaining Wayfarer defendants. So she gets to have, like, that's my feeling, she gets to have a casual aside, if you like. But I feel like the Wayfarer parties don't get to do that. They don't get to lump in things without being specific. I feel that way. That is my feeling about it anyway. But I could be entirely biased at this point. I'm not team. When I'm saying I'm not team truth anymore, it's that idea of when you're this far into it, if the truth comes along and it's different than what we think, we'll have to take it on the chin and deal with it then. But in the meantime, at this point, I think you're either team Lively or you're team Baldoni, aren't you? We'll deal if we're figured out to be on the wrong team later, then we'll have to hold our hands up to that. But in the meantime, pick a side, isn't it? At this point, I think. I'm just having a quick squeeze. There was one woman, wasn't there, somewhere or other that Blake was trying to reference, that supposedly Justin years ago invited to a hotel room or something, as if no man in the history of the planet has ever done that to a woman. It wasn't some woman that was saying things on social media or something, but I think Jen Abel or somebody made a comment that she's walking a dodgy path, is this lady, because she's trying to do something that doesn't exist, or words to that effect or something. It was somebody jumping on a bandwagon or something like that, and that's been the only kind of indication of anything else to do with Justin, really. But I think Blake was trying to make something of that other women have had similar experiences. um The Wayfarer party suggests that courts typically permit discovery only of prior misconduct complaints, not those post-dating plaintiff's complaint. The case law, however, imposes no such bright line. So if there's anything else that's post Lively's complaint, I guess that has to come out. So the Wayfarer parties therefore need not provide complaints unrelated to sexual or gender-based harassment, discrimination, or retaliation. If any such complaints exist, the complaints must likewise be limited to those involving the named defendants, including all employees of Wayfarer itself. So I'm not going to go into all of that, but you can see how much case law the judge cites. He likes case law, and that's what Wayfarer are not doing. But I do wonder, like I say, if that's for our benefit as much as anything. So Lively's allegations of ongoing harm justify certain extensions of the discovery window, but without more, they cannot justify perpetual discovery, especially given the potential that her allegations regarding a smear campaign overlap with advocacy. And that's why he needs to see Case and Coslow's things in camera, as to see where the overlap is as well there, isn't it? So the Wayfarer parties have to produce a categorical privilege log, because they were just going along with Case and Coslow's, weren't they, at some point? And Signal messages. Signal must be getting a boost to its business off the back of all of this. So the Wayfarer parties, they have not filed an analogous motion to compel, nor have they specified which request on ongoing discovery is appropriate. Yeah, it's like sometimes he's almost told. He's done this several times, hasn't he, the judge? It's like, well, you didn't ask for this. You could have compelled this. You could have filed such and such, even in terms of before his case was booted, Justin, the judge was almost like, why didn't you fight jurisdiction, wasn't he? It's you submitted to this, blah blah. It'll be interesting if we ever get those questions answered, why they went along with certain things or they weren't more aggressive, if you like, whether that was a strategy or whether it was about PR and how it looked to us, or whether it was coming from Justin that he didn't want that, although he's in this fight and he has to fight it, that he doesn't want to really harm Blake Lively. I think that's what she's not getting throughout all of this, is that why would the man do all of this through Jed and that, when he's said numerous times, and she doesn't want to believe him because she wants to believe that he's a hypocrite. But we've seen numerous times now where he's literally stated that he doesn't want to harm her, or he doesn't want to go down a certain avenue, or gets totally dirty. He has to do certain things. There's no getting around it. Well, there's so much that he's proved that he didn't want to do to her. I doubt that Justin wanted every negative interview she's ever done to come out and be inspected and all of that. Right. So that's that. Let's just have a quick look to see if there's anything else. You can see why I didn't want to tackle it the last day or so. This is just more to do with Jed, but I think it's all more of the same. I think we've gone through most of it. How many pages is it's 31? There's no way I'm doing this. I think I've done a pretty good video there, all in all. I'm really pleased for Perez. It'll be interesting now to see whether, let me just stop sharing. It'll be interesting now to see what the judge does in Las Vegas on Tuesday. I don't think any judge will want to touch the issue of freedom of speech, and I don't think you can argue that Perez Hilton is not a journalist. I don't see how that will wash. I think, I mean, Blake has very little on Perez in terms of his name so far being bandied around. There was that one text message, wasn't there? How do we get hold of Perez? He's looking like he's being supportive in terms of what he's producing and he's gaining traction. He will have reached out. There's no doubt that Perez, like Andy did, and possibly Candace Owens and Megyn Kelly maybe, approached their side, their PR or their team or whatever, about getting a quote. Andy's told you that he's had quotes that have been, to other media. The same quote has gone to other media outlets, and I'm sure Perez will have approached for a quote. He wouldn't have been doing his job had he not been doing. So of course his name would be on certain communications. So we just have to hang out for that one now. But yeah, my big problem at this point, and it's like how some of you have said on here, I think some of you have said on my comments, that maybe the judge is allowing Blake so much leeway and so much opportunity, if you like, because he's trying to prevent a situation where she can appeal. Because if so much went her way and she still couldn't prove this case, then she can't really appeal because she's had all the scope in the world to try and make it stick. And if it doesn't go her way, then she won't have a leg to stand on in terms of room to appeal, I guess. So maybe it is that. I get the feeling the judge has had enough of it all at this point, but I do think he possibly thinks, well, they do seem to be hiding a little bit, so maybe we have to give a little bit of leeway to see if this woman can come up with something. But I also think he's not unaware that she's not so far coming up with anything. So it's all very interesting. My main frustration right now is the backlog in the docket and why he literally doesn't just clarify. The arguments are in now as regards the Blake's second amended complaint. People have responded to it. Jed has been dismissed out of it once. I think the judge should just crack on and decide whether he's dismissed out of it again. I think that is fair, rather than going to through all of this dispute over what he should and shouldn't be producing and who should have been when that deposition should have occurred and all of that, because it's all pointless, it's all moot in my opinion if he's not even jurisdictionally to be held there. It's kind of crackers, isn't it? Anyway, so other than that, I have started putting my first book on YouTube, so I've been doing it chapter by chapter. There'll be a chapter released every day. And when I was reading it, I thought, oh, this is a longer book than I realised. It's my romance novel, Flora and the Homeless Gigolo, because some of you have been saying you quite like listening to my voice, or you quite like listening to my voice and it helps you sleep. So I thought, well, I might as well read one of my books and put it on the internet, and you can have it chapter by chapter and see what you think of it. If you kind of like my sense of humour or the things that kind of tickle me, then you might quite like this book. And it's quite racy and it's fun and it's very British. It's not too heavy, but it doesn't shy away from more serious things too, I don't think. And it pokes fun at all the romance tropes as well. It's because I spent a period of my life, like in my late 30s when I went into early menopause, I was having a really hard time. And the only thing I could do that kept me sane was like just reading romance novels, because nothing bad happens in a romance novel in general, or there's always a happy ending in general and stuff. And it kind of kept me sane, and it kind of made me start writing. I always make people laugh because people say, how did you come to write a book? And it always makes them laugh because I always say, well, it was 50 Shades of Grey that made me write a book. And people go, oh, 50 Shades gets so much stick, doesn't it, for not being well written? But it just kind of, I'd always enjoyed writing as a kid, and I'd always got a lot of praise for writing. I think reading 50 Shades, it just thought, because I've tried a couple of times in my life to write a book and always felt I didn't have the life experience. And so when that came along, I think it just triggered in me like the perfect storm of events again, that, well, you could start by writing a romance because they're not supposed to be believable. It's a fairy tale. You don't have to do a lot of research. It might be an easy way to start. And you've certainly done your own research on it with all the books that you've read. You've got an idea of what's expected. There's a certain rhythm to a romance novel, and they fit within certain subsections and all the rest of it. And men are supposed to have calluses in order to be manly, and they're supposed to be like that. So my books kind of poke gentle fun at that aspect of it. So I think they're quite unusual in that way, that anybody that likes reading romance will be quite tickled, because you'll almost see, like, the Taylor Swift effect, where you've got the Easter eggs that you notice about romance novels and things like that. So if you do like a romance novel, or you just fancy an easy read, you might quite enjoy them. So it's going to be in its own playlist on my YouTube channel. So you might see that popping up now. And each chapter's like about 30 minutes. So it's not going to keep you over long to do it bit by bit. It's easier than watching one of these videos. But do please look out for them, and just enjoy, hopefully, listening to my little voice. But please do hit that like and subscribe and share if you're enjoying what I'm doing here. And I'm always happy to hear from you too. And I will see you again soon.